ThinkPod, an initiative by ANM Global.
Welcome to ANM ThinkPod, an initiative by ANM Global. I am Umang Sheth, a senior associate at ANM Global, and today we are discussing the legal landscape of advertising in India. With compliances more crucial than ever, we have Ms. Anushree Rauta, the head of media and entertainment practice at ANM Global, here to break it down for us. Welcome, Anushree, to the podcast.
Thank you, Umang. I'm looking forward to this discussion. It's a very critical stage now with so many rules and compliances coming into place in the advertising space, and the right time to have this discussion.
Absolutely. I mean, it's very important for brands and companies to stay compliant with the laws. It's just not about putting a creative advertisement out, but it is very important to comply with the laws.
Absolutely.
Right. So let's start with the basics. While conceptualizing an advertisement, what are the legal aspects a brand or a company must look into?
See, one of the most important aspects is securing your intellectual property rights. So, right from your conceptualization stage, a brand would have, say, storyboard artists, they would have their creative team, they would have their writers.
Right.
And at each stage, there is different IP which is created. Now, with respect to copyright, we would have literary works such as your script. There would be artistic works such as your photographs, your images, your animation. So all of this is protectable by copyright, and it's important to understand the association, right? So say if the brand has its own employees working on each of these aspects and creating those works, it would be governed by Section 17 of the Copyright Act, which talks about first ownership. And subject to a contract to the contrary, typically an employer would be the owner of the copyright. Similarly, there's a concept of commissioned works. So if a brand is engaging a third party to develop certain works for them, then again they would be the owner, the commissioning party is the owner, unless there's a contract to the contrary. Ownership can be transferred. So authorship cannot change hands, it cannot be transferred, but ownership can be transferred. So if there is an assignment of copyright, say if a person has already developed a work or is to develop a future work, then copyright can be assigned in compliance with terms of the Copyright Act. One has to fulfill the conditions of Section 18, 19, mention your consideration, term, territory, so on and so forth.
Got it. So we understand that, creation of an advertisement has to be original, but however, what if the brand would want to utilize certain third-party content in the advertisement? Can they do so?
Absolutely. So when you're using third-party content, it's important to take licenses. One cannot use any third-party copyrighted work without taking adequate licenses.
Right, got it. So I understand that third-party licenses are very important. But what happens if these licenses are not procured?
So if licenses are not procured, then you run the risk of infringement. You could be sued for injunction. There could be damages which could be claimed. It could, you would land up in court. And to give you an example, see, music is very important for any advertisement. It connects with the audience. Now again, in music, there's a possibility that the brand may choose to have an original music in which they may engage a composer, a singer, and get an original song created for them. But it could also be possible that they take third-party popular track and synchronize it in their content. So it depends upon the brand and their choices. We've seen cases in which without securing adequate licenses, if brands have gone ahead and used any song in their advertisement, cases have happened. Like one example which I can think of is the recent case where Saregama had gone to the court and dragged Imami. Imami had used Ude Jab Jab Zulfe Teri for one of its shampoo advertisements, and the court directed Imami to deposit a certain amount in the court. The matter is still pending, but these kind of cases happen.
Got it. So you've given an example of original music versus a third-party sync music, right? Could you give us an example, like what would be original music? Any examples that you can think of?
So One example which comes to my mind is of Nirma. Like from childhood,
Absolutely.
we as an audience relate to whenever
Right.
that brand name comes. The tune of Nirma really comes to the
Right.
mind.
Do you want to sing 2 bits of it?
Oh, no. I wouldn't for fun want the YouTube fingerprinting technology to detect it and for us to get any claims.
Right.
But in any case, we wouldn't want this video to go viral for the wrong reasons.
Definitely. And one example you would want to give for, any advertisement which you're aware about using third-party sync music.
So I recently came across this Motorola advertisement featuring Kriti Sanon, and one of the popular tracks, Rangila Ray, was there in that. So, but that brings to my mind when we typically see that these kind of advertisements, they are for limited terms.
Right.
It's also possible because there's a proper fee which you have to pay to the music label for securing these kind of sync licenses.
Right.
And so that's why they would be for a limited term, and it depends upon the terms and conditions of the specific license.
Right, got it. So we've understood that importance of creating original music versus procuring proper licenses for third-party content in the advertisement. Now another aspect of conceptualizing the advertisement is engaging celebrities, right? What are the important points that a brand must look while engaging a celebrity?
See, when celebrities are engaged, there's a lot of money which goes at stake, right? Because brands pay crores of rupees to get these celebrities on board. And of course, it gives a credibility to the brand image. So it's for the brand, the most important thing would be securing exclusivity to ensure that the celebrity does not endorse any competitor.
Right.
So having a non-compete and exclusivity clause is extremely essential. It's important to have your category blocks to ensure that there's no overlapping in terms of what particular segment the celebrity is endorsing. And of course, your general legal safeguards in terms of taking adequate representations, taking adequate indemnification, because ultimately, if the celebrity breaches the terms of the contract, you would want to be indemnified. Important to have adequate exit clauses in terms of your termination for non-performance for breach by the celebrity. So these are some of the critical clauses which one should take care of.
Yeah, definitely. I mean, these are very important, and the role of celebrity is also very important. It takes the brand to another level. I mean, celebrities do bring a good face value for the brand. Recently, one of my favorite advertisements is, the 𝐀𝐍𝐌 advertisement featuring Mr. Rahul Dravid, and the whole Indira Nagar ka gunda hu main moment really blew up and it went viral. I mean, who would have really thought, the most patient cricketer, the wall of Indian cricket is engaged in a road fight in traffic. So, what a wonderful writing, and this has taken the brand to another level. So
absolutely, I kind of understand why you took that example, you being a cricketer yourself. But yes, the storytelling has become very important, and it plays an important aspect in terms of how brands are thinking about advertisements.
Absolutely. Now going ahead with another segment touching upon the creation of advertisements. From a creative angle, we've understood that securing intellectual property is important. But there are certain laws which a brand needs to comply.
Yeah, absolutely. See, it depends upon various factors, such as the genre of the advertisement, the medium in which it is being exploited, right? You have satellite, digital, print, there are different mediums. So we have ASCI which is the Advertisement Standard Councils of India. It is a self-regulatory body. It came into existence in 1985. And it has its own advertisement code. It's basically, the intent is to promote ethical advertising and to ensure that there are no misleading ads. So ASCI is of course one of the prominent players.
Got it. So you mentioned it is a self-regulatory body. So if it's a self-regulatory body, what are the powers or features of ASCI, and what are the consequences of not abiding by the suggestions of ASCI?
That's a very important question. See, so even though ASCI is a self-regulatory body, the ASCI guidelines find its relevance in various statutes. So for instance, under the cable television network rules, we have our advertisement code, which requires that no advertisement can be carried out on the cable service if it is violating the ASCI code.
Right.
which gives it a lot of teeth, right? It's not just a self-regulatory guideline in that aspect. In 2022, the CCPA, which is the Central Consumer Protection Authority, it came into existence under the Consumer Protection Act.
Right.
And the CCPA also has its own, guidelines for misleading advertisements.
Okay.
They have joined hands with ASCI. And so basically, ASCI can escalate complaints of non-abiding advertisements to the CCPA.
All right.
And CCPA, being a statutory body, has powers to take actions against the advertisers.
Right. And you mentioned about Consumer Protection Act and the CCPA. So is there somewhere the definition of misleading advertisement defined?
See, misleading advertisement, yes, it is defined under the Consumer Protection Act.
Okay.
And it's the term itself is self-explanatory. Right?
Yeah.
I mean, where you are misleading the consumers, you are deceiving them.
Correct.
You are, putting across advertisements which kind of trick the consumers in certain manner.
Correct.
So,
Which are not completely true.
Absolutely.
Right.
Absolutely.
Yeah, got it.
So basically, any false description of advertisements, false guarantees, deceiving the consumers, that would be your misleading advertisements.
Right. And I understand that CCPA has also established in the recent times guidelines called as dark patterns. Would you shed some light on it?
So dark patterns, it really refers to your user interface, your UI UX indexes,
Correct.
which trick consumers.
Okay, could you give some examples of dark patterns?
Sure. So one example which I can think of is creating a false sense of urgency. Right, where say, even though you don't have limited stock, but you prompt the consumers to really go and buy, saying that the stock will be, there are only 10 minutes left, and it will be out of stock if you do not purchase it.
Yes, got it.
Another example which I can think of is something called as basket sneaking. Now, when as a user you go and you add certain items to your cart, say if there is a certain item which has been added without your consent.
Okay.
And this could be, say, if you're booking a salon service and you realize later on that it's not just a salon service which you avail, but a subscription to the salon.
Is that added in free?
No, that's the point, right? That because you as a consumer are not realizing that something has been added without your consent and you've actually paid for it. Me as a consumer, I sometimes don't even check what all the items are, if there is a delivery tip, if there is another kind of a tip which has been added. So that is another example of a dark pattern.
Got it.
Another interesting one is something called as confirm shaming, where guilt is used as a tactic. So you would have seen in while booking tickets, sometimes platforms they ask you to take a travel insurance, and if say the platform puts things like I'll be insecured if I do not avail the travel insurance. So that's example of a confirm shaming where you're using guilt as a tactic.
I mean, I think I am a victim of this quite often. I mean, I always get this notifications from platform that, Umang, a gulab jamun is waiting for you. Where are you? And I end up ordering sweets and whatnot. So I think these are tricks used by the platforms to, get the consumer buying.
Absolutely. I mean, a lot of platforms may not be cognizant of this and could be inadvertently or intentionally, violating these guidelines.
Right.
There are many more examples. One interesting one is nagging. It's not in our typical family scenarios which we understand, but nagging, where basically constant pop-ups kind of annoying the consumers to, out of annoyance, go and buy the product.
Right. Got it. And we've understood about CCP and digital advertisement. What about satellite TV?
Right. So like I mentioned, we have our cable television network rules, which prescribes the advertisement code. And basically, what kind of advertisements should not be shown on television is governed under the advertisement code. So anything which is vulgar, which is not in compliance with applicable laws, all of that comes under this. And there are also restrictions in terms of the duration of advertisements, which can be shown for, during a particular hour. For instance, there is the limitation of, I think, 12 minutes for 1 hour.
Right.
So,
got it.
And in addition to cable television network rules, MIB also keeps coming up with its own advisories from time to time.
Right,
And,
got it.
yeah.
So in the recent times, I mean, this is really important for us to talk about is, the self-declaration mandate which was introduced recently, and the entire industry was, under a panic and they didn't have the right answers. Could you let us know what actually happened?
Sure. So this was in furtherance of the Indian Medical Association versus Union of India case, which is also called as a Patanjali case.
Right.
Basically, Patanjali had made certain claims in terms of their medicines being more effective than allopathic medicines, and which kind of prompted the IMA to go to the Supreme Court.
Right.
And the Supreme Court, it also asked Patanjali to remove certain advertisements, and that also prompted them to come with the requirement of self-declaration certificates to be uploaded before any advertisement is played on television.
Right.
This caused a lot of ruckus in the industry because every sector was impacted by it. And of course, there were logistical issues, there were technical issues. This was something new which was happening, and in a limited time frame. Nobody wanted to be in contempt of court.
Right.
Eventually, the ministry clarified that this would be only applicable for the health and the food sectors.
Okay.
The matter is still pending before the Supreme Court, and it would ultimately, be decided in due course of time.
Got it. So thank you for explaining in a great manner. But so now I understand that there are many laws which a brand needs to comply, but there are few sectors like alcohol advertisements, tobacco advertisements. How are these running?
So alcohol and tobacco advertisement is not permitted in India.
Right.
But brands find a way to do it through genuine brand extensions, which is permissible, of course, subject to the terms and conditions which are given under the ASCI Guidelines, under the Consumer Protection Act, under the CCPA 2022 guidelines on misleading advertisements. And for a brand to have a genuine extension, you would have seen, say, an alcohol brand having a mineral water or a soda or a ginger ale line.
Yeah, music CDs.
Yeah, that was back in the day.
Right.
But they need to, for being a genuine brand extension, they need to show certain, product sales, substantial sales, turnover. They need to show that, their asset investment.
Right.
There also is a requirement of independent certification by a CA with respect to verifying these claims. So these kind of guidelines have been introduced under these various statutes.
Right. And what about tobacco? Is there any precedence to this?
Again, tobacco advertising is not permitted, but one example I can think of is this Vimal and Dilbagh Pan Masala case, where the Delhi High Court in fact ruled that these products did not contain tobacco, and hence those advertisements were permitted under, they were not found to be in violation of COTPA.
Right. 100% free tobacco is
absolutely
okay. Right. Got it. So another industry touching these sensitive products is the gambling industry. How are gambling, betting or gaming advertisements running?
See, it's now a well-settled position that a game of skill is permissible, right? So, be it rummy, be it poker, be it fantasy sports, there have been adequate judicial precedents to lay that these are permissible.
Right.
They are not prohibited under law. So, advertising those would also be permissible, but this is a state subject. It's not a central subject. So different states have different laws and regulations which govern this. So brands have to be mindful of that while advertising in those particular states.
Got it.
Game of chance is not permissible, like betting, gambling. These are advertisements which are not permitted, and we have seen, especially you would see before any IPL league or any important cricket tournament. the Ministry of Information and Broadcasting, they do come up with certain advisories and guidelines
Right.
to kind of prohibit these betting and gambling ads.
They are really active during those times, right? Got
Absolutely.
it. So again, understanding that the game of skill elements, the games there are permissible to advertise subject to state laws, but I'm sure there would be certain compliances still they would need to address to.
Absolutely. So the ASCI guidelines do cover this. For instance, you cannot show a person under 18 years of age or minors participating in these kind of advertisements and games. And prominent disclaimers are required to show that there are financial risks involved. There could be potential addictiveness
Right.
of the games.
Right.
And this is applicable like across mediums. There are guidelines with respect to the size of the disclaimers, the prominence in which it should be shown,
Right.
and also to because this can be addictive and people do
Yeah.
use it as an alternative
Employment option. Right.
So it shouldn't be shown that it is an income opportunity.
Right. You have to play it very responsibly.
Absolutely.
Got it. So now in this segment, we can have a different perspective altogether. Now we've discussed about brands and companies, but as an influencer, as a celebrity, what are the things that the celebrities must be mindful about?
See, celebrities and influencers, they play a very important role in shaping the consumer behavior pattern, right? I mean, ultimately, it's these individuals who have the power to influence the audience in their purchasing decisions.
Right.
And we have ASCI guidelines with respect to influencers. For instance, you're required to mention, when you're endorsing a brand, that it is sponsored or it's a paid partnership. So these kind of labels are required to be given,
Right,
and both brands and influencers are responsible for the same.
Right, got it. And considering, there are certain sectors which are really important, which affect the society, like the health industry or the finance industry. Are there specific guidelines for that?
See, absolutely. Just like a non-lawyer should not be giving legal advice, the same analogy goes here. So say if it is a financial advisor giving, advice with respect to stock-related advice, right? They need to be registered with the SEBI. Likewise, for medical advice, you need to be a medical practitioner, registered medical practitioner.
Right, got it, absolutely. So, what about the celebrities? Do they have a different guidelines?
Absolutely. Again, ASCI has separate guidelines for celebrities as well. And this is basically to ensure that whatever products they are endorsing, those endorsements are genuine, and that they have verified their facts, they have done their adequate due diligence. So they need to give the statements to that effect. And this is again under the larger umbrella of preventing misleading advertisements.
Got it. So conducting due diligence is very important.
Yes.
And is there a help available to the celebrities to conduct the due diligence?
So the ASCI does have this feature where they help celebrities to conduct appropriate due diligence exercise. It's called endorser due diligence, and they have their expert team to do so. So this can be availed to mitigate the risks, because now there are heavy penalties involved in terms of misleading advertisements, even on the endorsers. It's not just the brands. Endorsers are also equally responsible. So I would say it's a good way to mitigate risks.
Right, definitely. Now, in this recent era, there is a lot of boom of artificial intelligence, and the advertisements are being created by using artificial intelligence, right? So, people are using the names, likeness, and images of celebrities. Is that permissible?
Using any personal attributes like name, likeness, images without permission is not permissible. And this goes back to our right to privacy case of Justice Puttaswamy, which was by the Supreme Court, right? Where the Supreme Court did protect the individual, the right of the individual to control their attributes and the way it is used.
Right.
And then we, of course, have the recent cases of Mr. Amitabh Bachchan, Jackie Shroff, Anil Kapoor, which has laid down jurisprudence in terms of personality rights in India, and where there have been third parties who have been injuncted from using their personal attributes without their permission.
Got it.
Another one was the 𝐀𝐍𝐌 𝐓𝐡𝐢𝐧𝐤𝐏 recent case against, which was before the Bombay High Court, where certain deep fake platforms were again injuncted from using his voice without permission.
So AI is definitely not a loophole for using someone's images and likeness.
Absolutely. I mean, all of these are applicable to AI platforms as well. And users should be mindful while using these AI platforms to ensure that, the output, who owns it. For instance, even for generative AI, a lot of users don't see the terms and conditions. It's important to see it, to see who owns the output. Otherwise, you run the risk of getting sued or there being duplication in terms of somebody else also using that output.
Right, absolutely. Very well said. I mean, great. So, I mean, there are a couple of list of laws which are to be complied, and I'm sure, the brands are doing it, but somewhere the brands would have faced legal challenges. Are there any cases which the brands and companies have been facing?
Yes, there are many cases which happen in the advertising sector. Especially, we've seen a lot of comparative advertising cases which happen. Where one example I can think of is the Horlicks and the Complan advertising case, where Complan kind of said that the 2 servings of Horlicks is equivalent to their 1, and there was an injunction granted, and they had to later clarify about the serving size. But like brands do use comparative advertising as a marketing tactic to showcase the plus points of their brand. Again, the jurisprudence has been well settled in this. Puffery is permissible because it does not require you to comply with the strict truth standards. You can say you are the best, but you cannot disparage somebody else's brand. That needs to be like verified. That there needs to be factual and verifiable statements to be provided for that.
Right. And because advertisement is kind of a story that you're putting out, have any brands faced any backlash from it?
Yes, sometimes it's not just about the legal framework. So recently we saw the whole Zomato Pure Veg fleet issue which had happened, which kind of prompted them to even take down the advertisement. And these are with respect to the societal impact as well, which these ads have. We can also think of that 𝐀𝐍𝐌 𝐓𝐡𝐢𝐧𝐤 Jewellers advertisement, which became an issue because a dark-skinned child was shown holding an umbrella, and it was construed to be having a colonial impact, having being insensitive. So brands need to be mindful not just about the legal framework, but also the potential cultural or societal and racial insensitivity which the content can have.
Right, got it. Even if the brand need not have that intention to do such a thing, but you must be careful about the social and economic factors of the society, and along with compliance of the law.
Absolutely. I mean, they need to ensure that the content resonates positively with their audience and doesn't even, inadvertently offend the viewers.
Right. Anushree, this has been a really insightful conversation. And before we wrap up, what are your 3 takeaways that you would want to give to a brand for compliance in the advertisement industry?
Thanks, Umang. So I'd say the key 3 takeaways would be of course, securing the intellectual property rights. Brands should ensure that they take their adequate steps in enforcing their copyright and in terms of even securing their copyright and trademarks and other intellectual property rights. Second would be in terms of the advertisements, not to give any misleading claims, even while doing comparative advertising, be compliant with applicable laws. And third would be, of course, follow the ASCI code, the ASCI guidelines, the extant laws with respect to the Consumer Protection Act and whatever guidelines are coming by the MIB from time to time.
Right. That's fantastic advice, Anushree. Thank you so much for joining us today.
Thank you so much, Umang. This was really a good discussion. Thank you.
Thank you. And thank you all for tuning into ANM ThinkPod. If you have any questions, you can reach out to us and we are happy to help you. Stay creative, stay compliant, and see you in the next episode.